Good afternoon, everyone, and welcome to Phil Fisher's webinar on AdTech and Privacy, what is next for the AdTech industry. For those of you who don't know me, my name is Leonie Power. I am a partner in the Data and Privacy team here at Phil Fisher, and I'm delighted to be joined this afternoon by my colleague Camille Ebden, a director in the Data and Privacy team, my colleague Matt Gregson, a senior associate in the same team, and my colleague Sophia Steiger, also in the same team and an associate in that team. So today we're going to be taking you through a fairly full agenda. We thought it would be useful to start off by having a recap on the AdTech ecosystem and some of the technical terms that are used in that context. And then we'll talk a little bit about Google's original plans in relation to the deprecation of third-party cookies and its subsequent change of heart on this particular point. We'll talk a little bit about the proliferation of various cookieless solutions in the market, what their future looks like, and some of the privacy challenges associated with those solutions. And then we'll move on to talk a little bit about what's next for the AdTech industry. So on that note, Camille, who's going to take you through the AdTech ecosystem and some of the technical terms used in that context. Camille.
Thanks very much, Leonie. So firstly, as Leonie said, we thought it might be helpful to have a high-level recap on the AdTech ecosystem and compliance challenges. So Leonie, if you wouldn't mind clicking through to the next and the next one as well, please. There we go. Thank you very much. So AdTech is, of course, all about connecting publishers, who on this diagram on screen are on the left-hand side, who have advertising opportunities available, known as advertising inventory or impressions, with advertisers who want to buy that ad inventory. You can see the advertisers on the right-hand side there. So these advertisers, they want to buy that ad inventory so that their ads will be displayed to individuals visiting those publishers' sites. Now, next to the publishers on the screen, we have the supply-side platforms, or SSPs. Now, these are essentially software that helps publishers to sell advertising inventory in an automated fashion via bid requests. So when a user visits a particular publisher website, a bid request is issued containing some information about the advertising opportunity, including some kind of device identifier. So that bid request goes from the SSP to an ad exchange. Now, an ad exchange is essentially a digital marketplace for advertisers and publishers to buy and sell advertising opportunities. The next party in the chain is often a DSP, a demand-side platform. Now, again, they're essentially software, but this time they are helping advertisers to decide which ad impressions to purchase and how much to bid on them. Now, they usually do this by some kind of cookie syncing, so i.e. some sort of matching of cookie IDs to help them profile users and determine the value of an ad impression for a particular advertiser. The highest bidder will win and their ad will be served. And this all happens in the time it takes for a page to load, hence being known as real-time bidding. Now, the diagram on the screen is, of course, quite a simplified example. In reality, there are many, many parties involved and who are going to be subject to privacy and GDPR, but who do not have a direct relationship with the end individuals. Now, by way of reminder, under e-privacy laws, certain transparency needs to be provided to a user and their consent obtained before there is storage or access of information on that end user's device, unless it's strictly necessary for the service requested by the user. And that consent has to reach the requirements of GDPR level consent. Now, additionally, to the extent that a party in the chain is processing information that is personal data, which is quite likely given ad tech is all about singling individuals out, GDPR transparency and legal basis obligations are going to apply. Now, all of this can be quite challenging in a complex chain, with many of the parties not having a direct relationship with each other, let alone the end individual. So moving on now to some technical terms, we wanted to have a look at some that are frequently discussed, and perhaps even more so in the context of new ad tech solutions that are emerging, such as the so-called cookieless solutions. Now, firstly, going to the real basics, we all talk about cookies and the cookie rule, but the term cookie is, of course, used quite broadly in Europe, including by regulators. But strictly speaking, cookies are just one of many forms of tracking technology, distinct from others such as pixels, HTML5 local storage, and local shared objects, to name a few. By way of reminder, specifically, a cookie in a technical sense is a small file of letters and numbers that's downloaded onto a user's device when the user accesses an online service. Pixels, for example, are one-by-one transparent images that are downloaded by a user's browser. However, as lawyers, we tend to talk about cookies to refer to any technology that involves accessing or storing information on an end-user device. And as many of you will be aware, it is that storage and access of information on an end user device that triggers the e-privacy requirement to have a user's prior consent, unless the storage or access is strictly essential for the online service or communication requested by the user. Now, when it comes to discussions of a cookieless future, there are increasingly references to terms like first-party cookies, third-party cookies, probabilistic matching, and deterministic matching. So firstly, first-party cookies. You're probably already comfortable with this term, but for completeness, these are cookies that are set and controlled by the website, the domain that a user is visiting, either by its web server or any JavaScript running on the site. Now, they're only accessible by the domain that created them, so making them generally less invasive than third-party cookies. Third-party cookies, again, most of you are probably very comfortable with, but these are set by domains other than the website that the consumer is currently browsing. So for instance, a news site might have cookies on it set by a third-party domain, such as an AdTech or analytics vendor, or a social media platform. Now, this third-party cookie is placed on the user's device and tracks the user's activity across different websites. So it's enabling multiple websites to collect and share data with the third party for analytics, advertising, etc., and perhaps to onward share it. Now, this tracking of users across multiple sites can, of course, be seen as invasive. Now, probabilistic matching uses various data sets and algorithms to identify the likelihood that users across different devices and applications are actually the same individual. So it's a statistical approach, and it considers whether various records agree or disagree on various identifiers such as names, addresses, or email addresses. As it's probabilistic, so based on likelihood, it doesn't require perfect matches, which is the big difference from the next term we're going to take a look at, deterministic matching. So this is the process of identifying and merging two different records of the same customer when an exact match is found on a unique identifier. So for instance, if a user logs in with the same email address across different devices, such as desktop and smartphone, deterministic matching links their profiles together. And applications like Facebook and Google Apps use email addresses for this purpose, achieving a high degree of accuracy, but sometimes lacking in scale when not all users provide the same specific information in different contexts. So moving on to the next slide, please, Leonie. We're going to turn to the deprecation of third-party cookies. Now, I'm sure you will all be aware that increasingly by regulators and consumer groups, there's been pushback on third-party cookies. So what are the concerns with third-party cookies? Well, firstly, as mentioned earlier, they track users across the web, they aggregate information from various different sites, and they're used to build detailed profiles. So they are therefore seen or can be seen as very invasive. Secondly, with so many parties typically being involved in third-party cookie use and data being used by those third parties for many different complex purposes, there are arguments that it's impossible for users to truly give specific and informed consent, which is required for the consent to be valid under GDPR and also in turn under e-privacy. So this was certainly the case in the original Belgian regulatory decision against IAB Europe regarding the Transparency and Consent Framework, the TCF. Now, thirdly, there are also concerns that bad actors can exploit third-party cookies to track users, to steal their personal information, or even to spread malware. As a result, we've seen in recent years a number of big players such as Apple, Google, Microsoft, and Mozilla announce plans to move away from third-party cookies to a so-called cookieless future. Now note, while we use the term cookieless future or cookieless solutions, it's really just referring to moving away from third-party cookies rather than all cookies. You'll see later on in this session that actually some of these cookieless, so-called cookieless solutions still involve cookies such as third-party cookies. Now, to give you some examples of moves by some of the big players, Mozilla's Firefox began blocking third-party cookies in 2019. Apple's Safari 13.1 began blocking all third-party cookies by default in 2020. Apple's more recent iOS prompts users to actively opt in or out of sharing their IDFAs, which are their identifier for advertiser numbers, with third parties. And also Microsoft Edge has an option to deny all third-party cookies. Now, meanwhile, Google have been looking at a number of initiatives to deprecate the use of third-party cookies as part of a wider initiative known as the Privacy Sandbox, which we're going to touch on over the next few slides. So moving on to the next one, please, Leonie. Thank you. So we've got on screen here a timeline of Google's deprecation of third-party cookie plans. I won't go through each and every one, but you can see that these plans have been in place for quite some time. But jumping to the 27th of July this year, Google made a surprise announcement that it was actually going to end its plan to block third-party cookies from its Chrome internet browser. Now, Google said that after considering the impact on the various players in the advertising ecosystem, they had decided to retain third-party cookies. The ICO issued an announcement that they were disappointed by the decision on the basis that, in their view, blocking third-party cookies would be a positive step for consumers. Now, Google has indicated that it will instead introduce new features in Chrome that will still allow users to have more control over their web browsing privacy. Reports are that it's discussing next steps with regulators. So it appears that Google isn't fully reversing from its alternative approach to advertising, but it will allow a third-party cookie-based system to operate in parallel. So what does this mean? Well, it means that ultimately people will potentially still see pop-ups asking them to turn cookies on or off in the future. But on the other hand, it appears that the privacy sandbox proposals and other cookieless solutions are still in play. So there's likely to be a duality of approaches, with cookieless solutions likely playing an increasingly significant role in the market. In any event, the other reasons to move away from third-party cookies still apply. So there are still those privacy concerns about third-party cookies. There's still a lot of regulatory pressure, as you can see from the ICO's comment. There's still user experience issues, as well as the fact that some of the big players have introduced already technical changes that mean that third-party cookies are not an option in certain contexts. So for instance, Apple and Google have made certain technical changes regarding third-party ad IDs on mobile devices. And over now to Leonie for a closer look at some of the so-called cookieless solutions.
Okay, thank you very much, Camille. So as Camille said, let's take a look at some of those cookieless solutions. And you'll see some of those solutions set out on the slide. So just to very briefly take you through those, we have solutions firstly that leverage first-party data. And when we talk about first-party data, what we're talking about is information that's collected directly from users who are interacting with a website or an app. And that data is essentially owned and controlled by the relevant publisher or advertiser. So it might include user registration information, browsing history of that particular user, purchase behavior of that user, demographic details, and the like. Now, it can include data collected from first-party cookies. So as Camille already mentioned, even though we talk in broad terms about a cookieless solution, what we're really talking about there is a move away from third-party cookies. Some of these so-called cookieless solutions often still involve the use of first-party cookies. But as well as data from first-party cookies, it could involve other first-party information like data collected from logged-in users. So leveraging that first party data allows advertisers to still create that personalized experience and to tailor the ad content and improve the accuracy of ad targeting. And then we've got the concept of fingerprinting, which boils down to analyzing the unique characteristics of a user's device or browser in order to create a digital fingerprint. And so those characteristics that are analyzed might be browser type, the screen resolution of the device, the installed fonts on the device, and the various other settings. And that fingerprinting essentially helps identify users even when cookies are disabled or deleted. However, as you might expect, it still has privacy implications, and it's often considered to be quite controversial because it has this potential for tracking users across websites in the same way as reliance on third-party cookies. And then there's contextual advertising, which essentially relies on the context of a web page or an app in order to serve the ad. So the advertisers will look at the content of the website or the app and the keywords that are used on the app or the website, as well as user behavior within that particular context. And so, for example, you might have an online article about travel, and that might display ads relating to holiday packages. So contextual advertising doesn't rely on individual user profiles, but rather on the content's relevance to the ad. Now, that said, cookies are still usually used, albeit not necessarily for the targeting, as we've said, because this is about contextual targeting, but it's used for frequency capping and anti-fraud generally. So we will still have some issues to consider around compliance with e-privacy rules, albeit not in relation to behavioral targeted cookies, behavioral targeted advertising. So moving on then to look at probabilistic modeling, well, that aims to predict user behavior without relying solely on cookies. Camille has already touched on this concept, but essentially it involves using statistical techniques to infer user interests and intent. And again, these models will consider things like device type, the location of the browsing, the time of day, the browsing patterns of the relevant user to make some informed predictions about likely user preferences and the likely relevance of a particular ad. Now, of course, there are certain issues with that, namely that it could be incorrect because it could be making inferences from a device, for example, that's used by multiple users. And so those inferences could potentially be quite intrusive and lead to embarrassment in some cases. Camille has already mentioned the Privacy Sandbox, and this initiative originated at the time that Google had announced its plan to move away from reliance on third-party cookies. The initiative is largely led by Google. Google is the main driver behind it. However, it has many different stakeholders, but essentially it involves a number of different proposals in relation to so-called cookieless solutions. The aim of these technologies or solutions is essentially to phase out reliance on third-party cookies and also to reduce cross-site and cross-app tracking while still ensuring that there is effective online advertising and helping to keep online content and services free. Now, there are many, many different proposals within the sandbox. I think over 30 or so. But we thought it would be worth just giving you a flavor of some. So on the slide, you'll see referenced contextual advertising, which we've already covered. But we thought we'd also mention another one, which is the flock or federated learning of cohorts. Now, the idea behind flocks is that advertisers would be able to target to large cohorts of individuals rather than to individuals themselves. And Flock would work essentially via browsers using an algorithm to group users into very large cohorts based on their browsing behavior. And those cohorts would be known as interest-based cohorts. So the algorithm would essentially use the URLs of navigated websites and the content of those websites and other browsing data that's stored on the user's web browsers in order to assign that individual or that individual device to an appropriate cohort. Now, each cohort would consist of thousands of users with similar interests. But the key point is that the specific browser data would stay on the device of the user. So it isn't shared with advertisers or wouldn't be shared with advertisers. So publishers and advertisers could only identify what cohort an individual belongs to. And the idea would be that cohort membership would be recalculated periodically to reflect an individual's most recent browsing behavior. That said, a number of concerns still remain, such as that these flocks may still reveal some information that could enable fingerprinting to be carried out in order to identify users, in particular where there's some kind of login facility. And then in addition, there is some concerns about the effectiveness of cohort-based targeting. Some organizations or website operators essentially have IP concerns regarding the buying of their habits of the buying habits of their customers being shared with third parties. So there's a couple of different concerns to be ironed out in that context. But as I've said, there are many different solutions and initiatives being proposed as part of this privacy sandbox initiative, and the idea seems to be that these would continue to run in parallel with potential reliance on third-party cookies in some instances. Another solution that is being developed, and one which you may have come across, is universal IDs or UIDs. And essentially what those are is a single unique user identifier that can be used by a number of approved partners in order to identify the same user across multiple websites and devices, but without using third-party cookies. You might have seen them referred also to as one-to-one identifiers or distributed ID systems, but essentially they work by publishers sharing hashed or encrypted first-party data about users to a universal ID company. And that company then creates a universal ID for the data. Now, it can either be done probabilistically or deterministically. And so if you think back to Camille's explanation of those terms, it means essentially that it could be done by using probabilistic user attributes roughly to identify users, such as an IP address, or it could be that deterministic data is used to more precisely associate a particular individual with a unique ID, and that might be in the form of some kind of hashed email address. So at its most simplistic, if you take a look at the slide, you might have, for instance, 3 different websites. Each of those websites are visited by the same user. So you'll see from the slide, user 123 visits an online newspaper and the IP address ends 475. That same user also visits a fashion retailer. We see the same IP address. That user is known as something different in the fashion retailer context. That user is user ABC. And similarly, the user visits a ticketing website. Again, we have the same IP address, but a different user ID. And so what is happening in practice is that each of these websites is collecting its own first-party information about the user, like their IP address. So that can be collected from the browser. And of course, if the user logs into that website, they might have information such as the user's email address. Now, if those three websites are integrated with a particular UID provider, when the user visits each of these sites, each relevant website sends some of its first-party data automatically to that universal ID provider. Now, that can happen through, for example, an application programming interface or some other communication channel. And then what happens on the UID side is that the UID provider processes the user data that's sent by each of these websites and checks whether that data already has a unique identifier assigned to it, assigned to that user's information. So is there a unique ID for that user's IP address or for that email address, as the case may be? And if not, it will create that unique identifier. And once there is that unique identifier for the user, the provider can send that identifier back to the web browser of the relevant websites that the user is visiting. Now, each of those websites in turn can share that identifier with their partners, like their supply-side platforms or ad exchanges or demand-side platforms, as the case may be. And if we take the example of the DSP might receive information from multiple websites regarding the same user ID and therefore knows that the same user has visited these different websites. So they can then determine if the user belongs to their target audience for a particular ad opportunity, and they can bid accordingly. So the ad opportunity may be more or less valuable to them depending on what they know about that user ID. So you can see the solution does not involve reliance on third-party cookies. It involves leveraging first-party data, but also using a third-party UID provider. Now, of course, that still has its privacy challenges. Now, just because it's not relying on third-party cookies does not mean that the privacy challenges go away, because as we can see from the slide, it still involves the processing of personal data, because we're talking about personal data relating to individuals, even though you don't necessarily know the real world identity of those individuals. If you're only, for example, engaging in probabilistic matching based on, IP addresses and the like, we know that still involves processing personal data. Certainly where you're involved in deterministic matching, again, albeit that the email addresses are hashed or pseudonymized, the UID provider doesn't know the real world identity of the individual, it's still personal data. So, and it also still involves personal data sharing. It often still involves personal data matching, and and potentially also involves large scale profiling. So all of the issues that we need to think of from a compliance perspective in relation to GDPR come into play. So is there a legal basis for that processing? And it's likely that the legal basis would need to be consent, because as we've seen, it involves a degree, albeit potentially on a smaller scale, of cross-device and cross-website matching. And so was likely to be perceived as intrusive both by the individual and by regulators. There's still a need for transparency, outlining to individuals how their data is processed and how it's shared. There'll still be a need for appropriate data terms, be they controller to controller terms, joint controller terms, controller to processor terms, as the case may be. And there'll still be a need, more than likely, in fact, almost certainly, to do some kind of data protection impact assessment. So all of the usual compliance aspects coming into play. And that's from a GDPR perspective. We also have concerns around compliance with the e-privacy directive. So again, as Camille said, cookies is used in a very broad sense. When we talk about it for the purposes of the privacy, it's a shorthand, if you like, for the relevant cookie rule. But the cookie rule actually talks about access to information on a device or storage of information on a device. And so anytime that that's happening, then that will trigger the so-called cookie rules, the need to get consent to the use of that cookie. Unless, of course, an exemption applies, but we know that those exemptions are very narrow. So we still need to then think about getting the necessary consents for the cookie, even in this context of IDs. Okay, and so with that in mind, and the fact that all of these challenges are still proliferating, I'll hand over to Matt, who's going to take us through what we think is next for the ad tech industry. Over to you, Matt.
Thanks, Leonie. So you'll see we've listed a few of our predictions and topics here on the slides, and we'll go into detail on a few of these shortly. Perhaps a high-level comment on AI to start. We know AI is not new to this industry and that automated technologies are used to manage real-time ad buying, selling, and placement at scale and have been for many years. But we would be remiss if we did not acknowledge the current proliferation and increased accessibility of AI tools and the increased regulatory attention in this area that comes with that, in particular, looking at the responsible use of those technologies. So what does that mean for you in 2025? Well, like most organizations, you will need to reflect on your approach to AI governance and use of these technologies in your organization. To do this, you should be increasing your AI literacy, establishing clear policies and procedures for the use of AI, and implementing robust oversight measures to the extent they do not already exist. For use of these technologies in or impacting the European Union, you will need to be familiar with the new EU AI Act. For those looking to familiarise themselves with the Act and its requirements, we have published a webinar series on this topic, which is available on the Fieldfisher Data and Privacy YouTube channel. But by way of high-level summary, we do not anticipate that most AI use cases in this industry will fall within the prohibited or high-risk classifications under the EU AI Act. That said, you should keep an eye out for any proposals to use AI for emotion recognition or algorithms to serve job advertisements. There are limited exceptions, which means that these activities can be downgraded from high risk, but the relevance of profiling, which we know is highly relevant to this group, constitutes an exception to the exception. So watch out for these activities closely. You should also keep an eye out for advertising linked to the use of chatbots or chatbot windows and the use of AI-generated content in advertising, including deepfakes, as these have additional transparency considerations under the Act. There are, of course, other ethical and legal risks linked to the use of AI, including from a copyright and image rights perspective. If you are looking to read around this further, I can highly recommend the IAB's white paper on legal and business considerations when using generative AI in digital advertising. Finally, I should also mention, with the proliferation of these technologies, you should keep in mind existing regulation in this area. In particular, Article 22 of GDPR, which applies when your use of technologies might have significant and legal implications for data subjects. For example, this might be potentially relevant for advertising to vulnerable groups. You will need to keep in mind the intrusiveness of your profiling, the expectations of the individuals concerned, and the way the advert is delivered. Let's move on to the next development, still on this slide, which is worth paying attention to, which is the subject of pay or okay, or pay or consent. We have seen several developments in this area this year, and we should expect those to continue into 2025. To briefly recap, there were a string of enforcements against large platforms like Meta concerning their lawful basis for advertising in 2023 and 2024, which ultimately led to some large platforms like Meta relying on consent for the processing of targeted advertising in the EU. That meant they had to give individuals the option to refuse their consent to targeted advertising, which is problematic when these platforms are ad-funded services. This led Meta to introduce an alternative subscription option where rather than consenting, EU users could pay to have Meta's services with no targeted advertising. Now, in the spring of this year, the EDPB published an opinion on the topic stating that in most cases, it would not be compatible with data protection law to provide users with a binary choice between either consenting to the processing of their personal data for behavioral advertising or paying a fee to access a service without targeted ads. Now, what they recommended was ensuring there's a third option introduced to users, free of charge and without behavioural advertising, and that would have a substantial impact on the analysis as to whether consent was freely given to the GDPR standard. Around the same time, the ICO published a consultation on the topic expressing similar concerns. We expect further guidance from the EDPB and the ICO on this topic in coming months. We can also expect market practices to change accordingly. It's notable this month that Meta has introduced changes to its subscription model in the EU to lower the price, which leads into the freely given a detriment consent analysis. It also introduced an additional choice, which involves the processing of less data. Now, let's consider some of the other 2025 trends. Moving on to the next slide. What's next for the TCF? Well, we're still waiting for the final resolution of the Belgian Data Protection Authority's February 2022 decision against and subsequent appeal by IAB Europe and its ultimate impact on the transparency and consent framework. Listeners might recall the CJEU provided its ruling on the issues relating to the appeal in March of this year, in which it found that the transparency and consent string is personal data, and that IAB Europe is likely a joint controller with other AdTech players, but only in relation to the use of personal data to indicate consent and legitimate interest preferences, but not in relation to subsequent use cases. Both sides claim that ruling is a win, but it is actually quite limited in scope. The next step, which we can expect early in the next year, is for the Belgian Market Court to hand down its decision on the merits of IAB Europe's appeal against the original DPA decision. That hearing was scheduled for the 23rd of October 2024, but that has now been postponed until the 8th of January 2025. In the meantime, IAB Europe has indicated that it continues to bring changes to the TCF, and with these developments in mind, it seems that the way is paved towards TCF version 3 coming to address some of these aspects, and we might expect this to follow in the coming year, although it remains to be seen what those changes will look like. Sophia, I think you are going to handle the next couple of trends.
I am indeed. So just first up, we're going to lightly touch on the EU's Digital Services Act. Under this act, there is a liability regime for online intermediary services. So, for example, hosting services, social media platforms, or online marketplaces. But then there are also potentially knock-on consequences for those servicing them. The rules have applied for a little while now for VLOPs and Velocities, which are very large online platforms and very large online search engines. These rules applied from the 16th of November 2023, and then for everyone else, they applied from the 17th of February of this year. So just to briefly summarise 4 key online platform obligations that are likely to impact AdTech. Firstly, there's increased transparency for ads. So platforms must make it clear when any information provided is an advert and provide meaningful information both about the ad itself and the parameters used to determine its recipients. There are certain prohibited acts for platforms, so they cannot target ads to someone who they reasonably believe is a minor. They cannot target based on profiling of sensitive personal data, and they cannot use dark patterns in online interfaces to deceive or manipulate. For the VLOPs and Velocities, they must build accessible ad repositories for the duration of the presentation of the advert, and then maintain these for 1 year after the last time it was presented. And the Commission is required to encourage the drawing up of voluntary codes of conduct to address advert transparency, the transmission of information for ad repositories, and meaningful information on data monetization. So we'll see what voluntary codes come out of that. If we can just go to the next slide. And then as we look forward, a new scheme is in development to create the world's first regulator-approved privacy certification for AdTech. The Coalition for Privacy Compliance in Advertising, or the CPCA, is a new non-profit organisation that has been established to manage a UK GDPR certification scheme for digital advertising. And what's particularly noteworthy about this endeavour is that the CPCA is working with the ICO to develop this certification. So what will the certification look like? Well, this does remain to be seen. there aren't many details available yet, other than that it will be based on existing ICO guidelines and that it aims to make compliance very practical. The CPCA are aiming to have the certification criteria and auditing methodology approved by the ICO in order to then be able to launch the certification in 2025. They also have their sights set on Europe with the aim to create similar schemes across the EU and to provide harmonised guidance across different jurisdictions. So we'll wait and see what happens there.
Great, thank you very much, Sophia. Okay, so that was a canter through all of the developments that are happening on the ad tech front and some predictions from us in terms of what we think are likely to be the next steps from a privacy perspective. There are a couple of questions from the audience, the first of which is, the UID concept appears to be an attempt to create a brand new alternative profile of the user exclusively compiled for advertising purposes. How does that sit with the foundations of the GDPR? So that's a really good question. So there is a perception to a certain extent that, you know, by moving away from reliance on third-party cookies, that you know, solves some of the compliance challenges. And I think, as we've seen from some of the examples that we've discussed, that isn't necessarily the case, particularly when we take account of what we mean by the concept of a cookie, or at least what the e-privacy directive defines as a cookie, which is access to information on a device or storing information on a device. And when we bear this in mind, we can see that a lot of these solutions, to a certain extent, will still involve accessing information on a device, and in some cases, indeed, storing an information on a device. And so from that perspective, will still trigger e-privacy requirements. We've also seen that, notwithstanding that a lot of these solutions may involve pseudonymized data, as is the case indeed in the ad tech world generally, where ad tech players don't know the real world identifiers of real world identity of individuals, you know, they still involve processing personal data. And so in terms of how these solutions sit with the foundations of the GDPR, the same concerns still exist insofar as you need to think about, well, what personal data is being processed for what purpose? How can I be sufficiently transparent about that? And what is my legal basis? Now, where you may have a little bit more flexibility is in terms of the level of intrusiveness of the processing that's been undertaken in the context of the solution. So generally speaking, however, if you're dealing with a scenario in which you're engaging in cross-device or cross website tracking, then the regulators have consistently taken the view that this is likely to be perceived as intrusive processing, and therefore is likely to trigger the need for reliance on consent. And so again, it's a really good question, because I think the answer is the foundations of the GDPR still need to be taken into consideration, and you need to go through your analysis, usually in the form of a DPIA that takes account of, well, what are my transparency requirements, what is my legal basis, etc. And indeed, what do I need to do to comply with the e-privacy legislation? The next question is around cookieless solutions. For cookieless solutions, what type of consent do you need to obtain? Is it consent for marketing, communications, profiling, or other? Again, a really good question, because this can often be quite confusing in terms of what exactly is triggering the need for consent. And in this particular context, it's a good example of the intersection between the GDPR and e-privacy legislation. And the e-privacy legislation is seen as what we, many refer to as lex specialis, which is the special rule. Now, the general rule under GDPR is that you need a legal basis for processing. And so depending on the intrusiveness of that processing, you may well need consent for the processing of the data. In addition, if there's a specific rule that applies, then the specific rule prevails. Now, we know that if you're accessing information on a device and that information contains personal data, then that involves the use of a cookie. And so there's a specific rule about needing consent. So if you need specific consent for e-privacy purposes, then you would use the same legal basis for processing the data as part of accessing the information on the device. In other words, as part of quote unquote dropping the cookie. So that's what's triggering the consent in that particular situation. So you've got both a GDPR consent and an e-privacy consent, and they align because the special rule prevails. In other words, you need consent to access information on a device. Okay, right. There's another question here. I think this is probably one for you, Camille, which is what are data management platforms and how do they fit within the AdTech ecosystem?
Right, thanks, Leonie. So in a nutshell, I tend to think of data management platforms, or DMPs as they're also known, as essentially a sort of storage and filing system for collected ad tech data. So ad tech players such as publishers feed the data that they've collected into DMPs, and the data is then aggregated and organized, often into audience segments. Now, depending on the particular ad tech player's role, the data can then be used for their particular purposes, such as perhaps to package and sell the data to other ad tech players. Now, DMPs, the other thing to mention is they typically integrate with demand-side platforms, DSPs, or SSPs, supply-side platforms. And this sort of enables their clients to drive data to these platforms so that they can apply the data to campaigns for targeting. But yeah, in a nutshell, I sort of think of them as sort of storage and organizational filing systems.
Great, thanks very much, Camille. Right, let's see. I think we probably have time for another question, probably one for you, Matt, because it relates to the TCF. Do you think that the findings by the Court of Justice of the EU, in particular that TCF string is personal data, will fundamentally undermine the operation of the TCF?
Thanks, Leonie. No, so I don't think it will. The conclusion appears to have been factored in by IAB in its approved action plan that the string is personal data. So while the findings are significant, they're unlikely to be fatal to the operation of the TCF. We think it's likely that the TCF will evolve with the aim of addressing this and some of the other requirements as well.
Okay, thank you very much. Right. Just looking there, I don't see, yeah, that looks like it in terms of the questions. So that brings us to the end of our presentation this afternoon. I hope it's been useful. If you've got any follow-up questions, then feel free to reach out. We will be circulating copies of the slides along with the recording to everyone who is registered for the webinar. So thanks again, everyone, and see you at the next one.